Breaking right now. A 16-year-old has been arrested in connection with the deadly shooting in Westwood. Cincinnati police say the teen is now charged with murder for the death of 21-year-old Michael McCody. Officers responded to a report of a crash and a shooting on Montana Avenue on April 21st. They say they found McCoy dead at the scene from a gunshot wound. Right now, it's not clear when the teen will be in court, but we, of course, will keep you posted.
A man charged and accused of dumping a woman's body in a trash can could get out of jail for $1,000.
Another man accused of leading police on a high-speed chase gets released as well.
And another man's bond is set at 10% of just $3,000 after police say he choked a woman until she went unconscious.
Now, those are just a few of the recent cases that Hamilton County prosecutor Melissa Powers has called attention to on social media, saying their bonds are dangerously low.
Our Chancellor Wynn joins us now live after speaking with the prosecutor and also a criminal defense attorney. Chance.
So the Hamilton County Prosecutor's Office says the low bonds, some of which aren't even requiring any cash for a defendant to be released, is a public safety issue. Now, in those social media posts from, again, the Prosecutor's Office and the Fraternal Order of Police, they're specifically citing one judge, Judge Samantha Silverstein. So I reached out to the judge's office, and a representative tells me that Judge Silverstein cannot comment on any pending matters. So therefore, I reached out to a criminal defense attorney who tells me that defendants are entitled to a bond that they can afford.
No one wants a dangerous criminal that could hurt them or their family members or loved ones out on the streets.
Look at our Constitution. It starts off and says you can't have excessive bail. Well, what's excessive? Excessive is a bond you cannot post.
Recently, the Hamilton County Prosecutor Melissa Powers and the Fraternal Order of Police have taken to social media to call attention to the bonds being set by Judge Samantha Silverstein, both claiming that Judge Silverstein is setting bonds too low for defendants accused of violent crimes, like 46-year-old Michael Simpson, who's facing charges of domestic violence, aggravated burglary, and strangulation. Judge Silverstein set his bond at 10% of $3,000. Powers says there's other cases, like the one against 38-year-old Micah Phelps, who's accused of leading police on a chase, reaching speeds over 100 miles per hour. Judge Silverstein didn't require cash at all for Phelps to be released, despite him having a criminal history that dates back to 2004.
She'll ask, what can you afford to a defendant? Somebody accused and charged of a crime that was arrested the day before. And if they say nothing, she gives them an OR bond. If they say $100, she gives them $1,000 at 10%. That's not following the Constitution, where you're required to consider public safety.
But criminal defense attorney Bill Gallagher says an Ohio statute allows for a hearing to consider no bond at all for a defendant accused of a violent crime.
If they're charged with a dangerous felony offense, you can keep them in jail. All you got to do is ask for a hearing, and we can keep those people in jail. But if you choose not to, have that hearing, then the question is, what's a fair bail to get them to come back to court?
Now, Powers tells me that type of hearing is for extraordinary cases like a serial killer. But for lower felonies that are still violent crimes like felonious assault, domestic violence, or having weapons under disability, a cash bond should be required. And sometimes a high bond should be set in order to keep a defendant in jail who may be a flight risk or a danger to the public.
She's taking the extreme position. You either do an OR or no bond hearing. When you have a violent felon or somebody that's shooting somebody in order to steal a car, and you let them walk out on an OR bond, how are you protecting the community? You can judge future behavior by past behavior, and this is immediate past behavior.
But to Gallagher, it comes back to the Constitution, prohibiting a judge from setting an excessive bond.
Whether it's $1 too high or it's $1 million too high, that's excessive. You're not supposed to do that. I think we're being asked to look at a crime and say, what's a high bond for murder? What's a high bond for a shooting? What's a high bond for a drug case? What's a high bond for a gun case? What's a high bond for a domestic violence or a DUI? That's relative, right? It's not the crime that should have a bail set on it. It's the person.
Now, you can actually check the bonds being set for a defendant accused of a felony crime by simply heading over to the Hamilton County Prosecutor's office, where it will show you the charges the defendant's facing and the amount of which a bond has been set. But for now, reporting live downtown with photojournalist Philip Krinsky, I'm Chancellor Wynn, Fox 19 Now.
Chance, thank you.